something that we do, so it's Doing Business Right. You will find it as well on Twitter. So I will have the pleasure to moderate the discussion between our three speakers, Tara van Ho, Tom de Boer, who will be joining us in a bit, I hope. He is around, and Lucas Roda. There, Tom is coming. Tom, you're there? Yeah.
Yes, sorry.
No problem. I was just mentioning you and saying that you would be arriving, and you are. The event will be structured as follows. Each of the three speakers will get 10 minutes to give their perspective on the case. And then we will open the floor for written questions from the audience. So please do not forget to write your questions in the chat box that is at the bottom of your screen. And then Mercedes will read the questions to the speakers. The event is as well live streamed on YouTube. So please mention if you prefer that that the question be posed anonymously, or that if we can also name you as the person that raised a particular question. So let me start by introducing briefly our three speakers, starting with Tara van Ho. So Tara is a lecturer at Essex University and currently the co-president of the Global Business and Human Rights Scholars Association, as well as a board member of the editorial board of the Business and Human Rights Journal. So obviously Tara, for people in the field, is a major figure in the discussion on business and human rights, and is also a major figure on the discussion on social media. So I encourage you to follow her on Twitter. If you don't, there is always something happening, and she's following passionately, I would say, everything that relates to business and human rights and beyond. So that is for Tara. Tom de Boer is a lawyer at the Dutch firm Prak & Oliveira. So Prak & Oliveira, for those who are non-Dutch, and this event is a bit geared towards also an international audience. It is, I would say, the law firm in the Netherlands that does most of the BHR, business and human rights litigation, but as well representing clients. And Tom, I speak under your control, but before the Dutch national contact point. So it's not only court litigation; it's also working with the national contact point. And Tom, you specialized in international law and liability for human rights violation, and that's why as well you are part of the legal team that is representing the claimants in this case before the Dutch court. And finally, the final speaker is Lucas Roda. Lucas, you are an assistant professor at Utrecht University, where you recently defended, it was in December last year, your PhD on jurisdiction over foreign direct liability claims against transnational corporations in EU member states. So also quite a fitting topic for the discussion today. But also, interestingly, I found when I was looking up a little bit your bio, that you have a quite long-lasting relationship with the Kiobel case, because your master thesis, which was awarded a prize in 2013, dealt already with the possible implication of the then US Supreme Court decision in Kiobel. So also, obviously, a fitting speaker for today. So, as many of you will be aware, the tragic deaths of the Ogoni 9 and Shell's alleged involvement in it have a special place in the business and human rights discussion. The name Kiobel is forever attached to the decision of the US Supreme Court that dramatically curtailed the reach of the Alien Tort Statute and put almost an end to strategic litigations against transnational corporations in the United States. So this decision, in a way, triggered a turn away from the US as a forum of choice to litigate those cases towards EU jurisdictions, and in particular towards the UK, but as well the Netherlands, and that's why we're here. And there is, I think, no better case, obviously, to illustrate that shift than Kiobel v. Shell, now before the Hague Court. So this discussion that we will have today, our aim in organizing it was also to really familiarize an international audience with the key issues that are raised before the Dutch court and that are often discussed, obviously, rather in Dutch than in English. So that was our core aim in organizing the event. We will start with Tara, who I have asked to walk us through basically in a very short time. So this is quite a challenge to walk us through the lengthy history of the Kiobel case, briefly through the US Supreme Court ruling, and to situate the case in the broader business and human rights discussion. Tara, the floor is yours. You have 10 minutes. I will be quite strict in enforcing them so that we have a bit of time for the discussion.
Thanks, Antoine. And I appreciate your being strict in the time management. I intend to use my 10 minutes to do three things. First, I want to situate the discussion of Kiobel in what was lost. So this is what Antoine was just saying. I'm also going to examine the case's trajectory and its impact on the field of business and human rights. And then I finally want to consider where we are today and where we need to be tomorrow when it comes to remedies. I'm going to try not to touch or step on the toes of either of the other two speakers, but we'll see what happens. So let's start by talking about what was lost. On October 31st, 1995, 9 men were convicted of a murder, of 4 murders in the Niger Delta. Baranim Kiobel was one of them. On 10 November, without subsequent appeals, they were hanged. 2 days later, Shell signed a $2.5 billion gas deal. Esther Kiobel was an outcast. She lost her job. The other women faced social reprobation. That's what happened, but how did we get here? Shell had signed its first agreement in 1936. Now, those of you who are forgetting your global history might forget that in 1936, Nigeria was not a free country. It was not a democratic country. It wasn't run by Nigerians. It was run by the British. And it was the British colonial rule that granted Shell the license to operate, not just within the Niger Delta, but to prospect throughout all of Nigeria. They discovered oil in 1956. They began their first shipment in 1958. But in 1973, the military government acquired 35% of the oil. And by 1995, there was significant pollution throughout the Niger Delta. It was this that led the Ogoni leaders to protest Shell's involvement in the area and the environmental pollution that was wreaking havoc on their homeland. By the time the United Nations Environmental Program would assess the damage done to the Ogoni lands in 2011 and again in 2018, they determined that it would cost $1 billion to remediate the damage done. Shell had a particularly close relationship with the military. 80% of the military's revenue came from gas and oil exploration and exportation. And when it comes to foreign state involvement, it's worth noting that 50% of US oil was coming in from Nigeria. When it came to the trial itself, Shell was involved in the trial, not actively, but passively as an observer. In the midst of the trial, Shell was present. The international media was not. The trial was held in secret for everyone except for Shell and the Ogoni leaders. I want to read just briefly so that we can understand what happened and how the Ogoni leaders felt about the case. This is from Ken Saro-Wiwa's final address to the military-appointed tribunal. He was not allowed to deliver the address. But what he said was, Shell is here on trial, and it is well that it is represented by counsel, said to be holding a watching brief. The company has, indeed, ducked this particular trial, but its day will surely come, and the lessons learned here may prove useful to it, for there is no doubt in my mind that the ecological war that the company has waged in the Niger Delta will be called to question sooner than later, and the crimes of that war will be duly punished. The crime of the company's dirty wars against the Ogoni people will also be punished. That was 25 years ago. The punishment hasn't happened yet. In 1996, Esther Kiobel and the other wives of the Ogoni leaders filed the first case against Shell. Without the Brussels Regulation 1 for the EU, they had to look for a place that would house their claim outside of Nigeria. Obviously, when the Nigerian military was behind the trial and the execution of their husbands, it was not the appropriate venue for consideration of their claims that were deeply related to the relationship between Shell and the Nigerian military and the harm that they inflicted on the Niger Delta. So in 1995, they filed the first case. They went to the United States, which had the Alien Tort Claims Act, or the Alien Tort Claims Statute. The statute was adopted in the United States in 1789, but it went largely unused until the 1980s, when it was used first for traditional human rights abuses, the enforced disappearance and execution of people by military leaders, torture. Only in the 1990s was it started to be being used against corporations. And the Shell case was one of the first cases in the United States under the Alien Tort Statute to claim that businesses had violated international human rights law. Using the Alien Tort Statute was necessary because the United States has, as many other states did at the time, what was called forum nonconvenience, a rule that would allow for courts to dismiss cases that were brought before it if another court should actually be a better place to hear the case. Factors that are assessed in this include things like, where are the witnesses located? Where was the harm done? How easy is it to get translation? Who understands the law at the area? What this ultimately means, though, is that there's great deference to the location of the harm. Since this harm happened in Nigeria, a traditional tort case in the United States would have been dismissed in favor of Nigeria. What the Alien Tort Statute offered, however, was a different approach to the law. The statute provides for foreigners the right to sue in US federal courts for any violation of international law, customary international law. To take the case forward, a plaintiff needs to show that they actually have suffered a wrong under customary international law, which is a high burden. As we know, customary international law, as opposed to treaty law, is a little fluffy at times. It's a little uncertain. And you might know it at some point, but it's not always certain at the point that the harm happens, whether or not you're breaching customary international law. When I teach this to my students, I talk about customary international law as being like true love. It requires action and thoughts, and you measure it over time. And if I came home tomorrow and said, hey, mom, I met this guy in the bus, and it's definitely true love, my mom would have a right to say, are you sure about that? But when my great-grandparents were married for 60 years, no one asked them whether or not they really, truly loved each other, because over time, it was clear that they did. There were enough public proclamations. They had shown through their actions that they loved each other. But showing that a business owes customary international legal obligations is quite difficult. It remains quite difficult. And that's because it's unclear whether or not businesses are actors or just subjects of international law. That was a case that Esther Kiobel had to face. It was a case that the Ogoni leaders had to face. They had to be able to show that Shell owed an obligation to not be engaged in the torture and extrajudicial killing of the Ogoni leaders. Whether or not Shell owes that has never been decided in the United States. Instead, in 2013, in one of the first of two cases in which the US Supreme Court dramatically restricted the use of the Alien Tort Statute, the US decided that the Kiobel litigants could not bring a case to the United States because not enough of the case touched and concerned the US. This is where it's important to go back and remember that the US imported 50% of its oil from Nigeria. It had a vested interest in ensuring that that oil continued to flow. And yet when it came time to accept responsibility, when it came time to enforce responsibility, the United States took a very hands-off approach. It continues to take a hands-off approach. When Shell takes the cases, what Shell disputed before the United States and what it has disputed until recently before the Dutch courts was not whether or not it was responsible for the killing of the Nigerian leaders, but rather whether or not it should be held responsible, whether or not it should have to face on the facts the claims by the Ogoni leaders and their wives, by the wives of the Ogoni leaders. We're only now getting to the facts of the case. And that's a problem because we are 25 years on. And when you allow for cases like this to last for 25 years, evidence becomes more difficult to bring, witnesses die or leave. And what we're asking fundamentally of the victims, what we're asking of Esther Kiobel, is to keep a resilience for 25 years in the hope of justice, when every single opportunity for remediation is closed in her face. 25 years. And the reality is that when we talk about where we are today, that is still where we are today, right? We are finally getting to the facts of a case from 25 years ago. And this is not unusual within business and human rights. It is often the case that these claims go unremedied for not years, but decades. And we need to understand that, because if what we want to do is construct an appropriate response to business and human rights in the future, we need to understand where we are today and the failures of the system now. The right to remediation is firmly established under international law. There is a right to remediation if you have been the victim of a human rights violation. But establishing that still relies on the goodwill of states and of businesses. So for states, they are supposed to provide judicial remediation. If a state is a party to the International Covenant on Economic, Social, and Cultural Rights, that is very clearly not just about remediations to harms within their territory, but also harms by their foreign national or by their corporate nationals when they operate abroad. That's what the Committee on Economic, Social, and Cultural Rights has established. And yet still today, most states have significant barriers, whether it's in terms of establishing jurisdiction, whether it's in terms of establishing enough material for evidence. Rules of discovery can be significantly consequential in whether or not a case is brought forward, whether or not a case can be heard. Shell keeps the documentation. It retains control of the documentation of its involvement in Nigeria over the years. An average person in Nigeria does not have access to that material. And how we construct the rules of discovery can have a significant impact on the issue of remediation. There are potentials for the future. Thank you. There are potentials for the future to change this. The United Nations is currently negotiating a treaty on business and human rights. Within the treaty's draft are provisions on mutual legal assistance intended to provide and ensure that victims can access appropriate judicial remediation. That's still a few years off. If you're going to ask me for an honest estimate, I'm telling you it's at least 10 years away before we have a treaty on this. That leaves the responsibility with the states, specifically with the home states of corporate nationals, not just within Europe, but elsewhere. We have seen transnational cases taken outside of Europe and the United States, including global south to global south cases. This is significant. States are starting to realize that they have a responsibility to respond to the impacts of their corporations. And yet still, when we look at the national action plans that states adopt for business and human rights, when we look at what states are focusing on when it comes to business and human rights, European states have not and continue not to address the impact of their remediation systems outside for victims who are harmed elsewhere. So we have waited for 25 years for Esther Kiobel to finally have an opportunity for justice, and the justice in which she is getting, the hope of justice that she has right now, still sits on a fragile bed. It sits on a fragile foundation, not just within the Netherlands, but within the entire EU. And if we don't fix that fragility, then the promise of a right to remediation is pointless. It's useless. If you cannot use it, there is nothing to it. And so that's where we sit for a field of business and human rights. And my hope is that the Dutch government will respond to this in its upcoming national action plan by really embedding reforms to the Dutch legal system so that Esther Kiobel doesn't have to continue to wait longer and longer, and so that future Esther Kiobels don't have to wait 25 years for justice. Thank you, Antoine.
Thank you, Tara. Well, thanks a lot. And that was really a kind of rather longue durée, big picture take on the case. And now it's a really nice transition to the more pragmatic, really focused on the case intervention of Tom. Tom obviously is representing the claimants, and he will be speaking about the arguments that are being raised right now, that were raised in front of the Hague court, and also as well the counter arguments that were opposed by Shell's lawyers in that particular instance. So Tom, you I think have a PowerPoint. Fingers crossed that it works smoothly. You also have 10 minutes, and I will give you a little sign when we're coming to the end.
Can everyone see the PowerPoint? Great. Thanks, Antoine, for the introduction and for the invitation. And Tara also for introducing like the broad spectrum of the case. Indeed, I'm going to delve into more detail into the current case pending before the Dutch court. It's going to be a very short introduction because even when we zoom in, or especially when you zoom in, it sometimes becomes even harder to put it in words in 10 minutes. I tried to go to the next slide, but it doesn't work.
Maybe with your keyboard.
Yes, there it is. I very shortly, because Tara already gave a very comprehensive introduction into the background of the case, then I will touch upon the practical issues that are involved in these kind of transnational cases. And then I will delve into the relevant questions and arguments in the current procedure. If we look at the background, I'm mainly focused now on the tribunal situation which started in 1995, when Ogoni 9 were actually tried before the Civil Disturbances Tribunal, which was actually a sort of extrajudicial procedure, which was later framed by John Major, the Prime Minister, then Prime Minister of the United Kingdom, as judicial murder. It was actually a way to eliminate the Ogoni 9, or actually the Mossop leadership that was harming the interests of the government, but also the interests of Shell, because Shell pulled back from Ogoniland in 1993 for reasons of the protest, actually. Tara already went into, there were actually two cases in the US. Maybe that's also good to point out. In one of the cases, there was a settlement in 2009, $15.5 million. But Kiobel, so Esther, Kiobel, and the other plaintiffs, they decided to move on with the case because they didn't want to settle. They wanted to have their case tried on the merits. And so they didn't settle in 2009, but they went on with the case. And the question in 2013 obviously was what to do now, because it was kind of a blow, of course, for Esther, who is really also the driving force behind the current case. You see Esther here on the right on the picture, together with Victoria Bera, one of the other plaintiffs, and my colleague Ghana Samkalde. We're doing the case with 3 lawyers, also with Alice ten Verget. So the question was what to do, and is it possible to actually bring this case before the Dutch courts? And maybe it's good to point out that in these kind of cases, NGOs really play an important role. In this case, Amnesty International asked us to look into the case, put us in contact with Esther Kiobel, and still supports the case both financially and logistically. But before you decide to take on a case, it's very important to think about the practical issues. And as Tara already pointed out, there are many in these kind of cases, and especially if there are 20 years, if we are 20 years after the unlawful acts. So the first problem is the evidentiary issue. So how to collect evidence in Nigeria, for instance, how to deal with the fact that Shell is in possession of most of the evidence, how to deal with the fact that it will be quite hard to subpoena witnesses from Nigeria, to effectively subpoena witnesses from Nigeria. We were kind of lucky that we had such a big history of the case in the US, and were given the documents of the US case, and that in the US there is this discovery procedure, which we don't have in the Netherlands, unfortunately, which is, in my view, a great way to at least balance the equality of arms a little bit. Because in this case, there was a lot of material, internal documents from Shell, etc., who had to be presented to both parties. It took us a lot of time to go into, to work through all these, let's say, a room full of binders with information, but in the end, we did so. Another hurdle in these kind of cases is the financial part. In the US and in the UK, it's possible to work on a no cure, no pay basis. And often also, if you win the case, there is a sort of success fee. In the Netherlands, this is prohibited. There can't be, according to Dutch law, there can't be an interest of the lawyer in the outcome of the case, and therefore you need to be paid on an hourly basis, which means that must be paid by someone, or by an NGO, or by legal aid board, or whatever, but you always have to secure the payment beforehand. And in these kind of really big cases, as I said, unfortunately, we had Amnesty International on our side, and there's kind of a good legal aid system in the Netherlands. But in these kind of cases, this can really be a hurdle even before you start the case. But we decided to look into it and to actually start the case, and then we had to look into the question whether Shell could be held liable for the arrest, detention, and for the execution of the plaintiff's husbands. And we had to look into the fact whether Shell was an autonomous perpetrator or whether it was actually complicit to the actions of the Nigerian regime. And in the writ of summons, we have put forward a number of arguments to underpin Shell's liability. And to start with, we said that Shell was actually, wait a second. Shell was liable because it invited and also incited the regime to violently suppress the Ogoni protest and to eliminate Mossop and his leadership. And it did so by repeatedly stressing, repeatedly making clear to the Nigerian regime how important it was for the state's economy to quell the protest, so to say. It did so many times, and our argument is that at a certain point, the government felt the need to intervene, and it did so by starting Operation Restore Order in Ogoniland. And this was a military intervention taking place in Ogoniland, and instead of distancing itself from the government, Shell decided to not do so. It was actually, we have proved that it was paying commanders. It also procured, or it was willing to procure arms in this period. And also, interestingly, it was running an intelligence network together with the state security service. So actually exchanging information and having informants in Ogoniland and exchanging information with the regime. The next argument we had was that Shell was interested in and also instrumental to the outcome of the Ogoni 9 trial. Tara already mentioned the watching brief. And actually Shell asked one of its lawyers, or many of his lawyers actually, to be present during the trial and to hold a watching brief, which is kind of weird given the fact that it was a murder trial. So Shell didn't really have any involvement in the case. It was about, it was a staged murder trial, but at the same time it was about murder. It did nothing to do with Shell, and Shell didn't really have an interest in the outcome. But still, its lawyer was there from the beginning to the end. Another point, very important, was that two of the prosecution witnesses came forward during the trial already, during the Ogoni 9 trial, and said that they were bribed. And they said they were bribed by the government and Shell, and they were asked to provide false testimony, and they were promised a sum of money, but also a job at Shell in return. And the last argument, we have put forward many arguments, but these are the most important, was that Shell, or actually Brian Anderson, the then managing director of Shell, he offered Ken Saro-Wiwa's brother, and also one of the lawyers was present who we spoke to. He offered to influence the outcome of the proceedings under the condition that Mossop would cease its protest against Shell, which really showed that Shell thought it had the power to do so, and to influence the Abacha regime. We based this on Nigerian law because this, according to international private law and the lex loci delicti principle, Nigerian law applies or the law where the wrongful act took place, or the place where the wrongful act took place, determines the applicable law. So we apply, in this case, the African Charter on Human and People's Rights and the Nigerian Constitution of 1979, which were both applicable in 1994 and 1995. So this is different from the other Shell case that is still pending in before the Dutch courts, which is about the oil spills. That one is based on tort law, so that's different. We have still invoked tort law on a subsidiary level, but our primary argument is directly based on human rights provisions, Nigerian human rights provisions, which is possible because these provisions have horizontal effect in Nigeria and can be invoked directly. So what is the current state of the procedure in the Netherlands? On 28 June 2017, we have filed the writ of summons on behalf of 4 plaintiffs. So you've seen 2 of them on the picture already, Esther Kiobel and Victoria Bira. Esther lives in United States, Victoria lives in Canada. And Blessing, Ken Nordu, and Charity Levula, who both live in Nigeria and have never filed a case before. They've never felt they had the chance to do so in Nigeria. We have summoned 4 defendants, all Shell, but different parts of Shell. And the first defendant is Royal Dutch Shell, which didn't exist in 1995, but is the current parent company of Shell. And we have also, to be on the safe side, summoned the 2 parent companies that existed in 1995, Shell Petroleum and Shell Transport and Trading. And of course, Shell SPDC, so that's the Nigerian subsidiary of Shell. Shell's response was received in April 2018, the written response, and then a court hearing was scheduled on 12 February 2019. And on 1 May 2019, the Hague court rendered its interim judgment. And also here, there were some procedural questions that had to be answered before the court could delve into the substantive questions. Actually, if you follow this link, there's also an English translation of the case, so that's helpful for for the international audience of this session. First question was pertained to the competence of the Dutch court, or the jurisdiction of the Dutch court. Shell claimed that the Dutch court didn't have jurisdiction. It claimed that the claim against the parent company wasn't sufficiently strong, and also that SPDC acted alone and couldn't be held responsible before the Dutch courts. Luckily, the Hague court ruled that it is competent to rule on the merits, and it based itself on Article 7 of the Code of Civil Procedure and Article 8 of the EX Brussels I regulation. It actually said that since so the plaintiffs, base the claim on Shell as a group, and actually Shell acted in concert, acted as one body, so to say, during the unlawful acts, given the fact that the parent companies were informed about everything that was happening, every contact with the Nigerian regime, etc. The court ruled that the claims against the defendants were based on the same facts, circumstances, and legal basis, and therefore there is jurisdiction to rule on the merits. Another hurdle was the limitation period that was invoked by Shell. Limitation always seems to be procedural, but it is substantive, and therefore also to this issue Nigerian law applies. And in Nigerian law in 2009, there were new fundamental rights enforcement procedural rules were adopted, in which limitation altogether was abrogated. So there simply didn't exist any limitation period in human rights cases anymore. And the court had to decide whether the fact that in 1995 there was a limitation period, whether that meant that the limitation period still applied. But there was a Nigerian case law in which Nigerian courts ruled that the moment of invoking the human rights determine the question whether there is a limitation period applicable or not. And given the fact that we invoke the rights after 2009, so under the new rules, so to say, means that there's no longer a limitation period. So that was a great result on the procedural issues. On the negative side, there were the court has also already rejected in the 1 May 2009 decision some of the substantive arguments. It actually really wanted to focus on direct role of Shell in the bribery of witnesses mainly, and other ways it could have contributed to the outcome of the Ogoni 9 procedure. So we had focused a little bit more on the broader scale and the responsibility of Shell, given its intricate relationship with the regime. But the court really wanted to focus on direct evidence. And it allowed us to give evidence on Shell's involvement in the bribery of witnesses and the causal link between the bribery and the eventual human rights violations. This led to witness hearings, first on 8 and 9 October 2019. 4 witnesses were heard, 3 witnesses who claim that they were bribed by Shell, and 1 witness who was a defendant and a lawyer at the same time, Lede Mite, was also vice president of MOSOP, of the resistance movement. And they were heard in Dutch court over 2 days, which was quite kind of special because 2 of the witnesses had never left Nigeria. They were never in another country than Nigeria before, and this was also kind of a challenge because their visas were refused first. So it was really a struggle to get them here, but in the end it worked out. And I think it's important for us. It was really important that Esther was able to look them in the eye. Victoria as well was there during the hearing, and actually felt afterwards, she told us that she felt a kind of reconciliation because they came clear, so to say, they came clean, so to say, about what happened. And she really felt, she actually wrote on Facebook, "I forgive them." So I think that was a kind of, I think a really important outcome, which also shows how important it is to have these cases ruled on the merits. Due to COVID, the other witness hearing of Femi Falana, also an important human rights lawyer in Nigeria, who was one of the lawyers of the Ogoni 9, was postponed, and we had it last month. It was, in the end, wasn't possible to travel to the Netherlands, so it was a video hearing, which was also interesting. So now the written, yeah, I'm fine. Yes,
2 minutes still.
Great. This is the final slide. So now we have left a round of written conclusions after the witness hearings, in which we actually draw conclusions on the basis of the hearings and try to persuade the court that the hearings led to the sufficient proof for liability of Shell. If that round is finished, then the court might have other evidentiary questions or other questions to the parties. But if it hasn't, there will be a final decision, hopefully positive final decision of the court sometime next year. So that's what we hope for. Thank you very much.
Thank you, Tom. Now let's turn to Lucas. Lucas is obviously very well versed in all issues connected in particular to jurisdiction, but in general to the application of private international law in this type of disputes. And I have asked him to reflect a bit on the issues raised with regard to jurisdiction, as well as applicable law, and bring in some comparative perspective to the Dutch case. So Lucas, the floor is yours. Also try to keep to the 10 minutes so that we can have a little bit of a discussion.
Yeah, thank you, Antoine. Yeah, I'll try to keep it in the 10 minutes. I really will try, but do cut me off if I go over time. I think the most interesting bits are in the beginning anyway, and the rest, and also try to not to overlap too much with the previous speakers who've been, I think, given an excellent introduction into not just the background of the case and the case itself, but also I think some of the fundamental issues of law that are in the case. So why isn't this? Yeah, here we are. So like Antoine said, I did my PhD research on mostly jurisdiction in these kinds of cases, but I've sort of come across most of the other legal issues as well. And in my own research, I sort of tried to flesh out like 4 different factors, what I call factors for feasibility. So 4 different sort of hurdles you have to go over in order to even be able to present a viable case before the court. And this is not, and I also will not discuss the substance of dispute, which I think Tom has already done much better than I could ever do. But these are sort of, you could say, the gateways to actually finding a claim like this. And when I say like this, I mean that this case, I think, fits within a trend that you can see first within the US, but now increasingly in the EU, of what I call foreign direct liability cases. So these are transnational claims, so that the facts usually occurred somewhere else than where the case was brought. They're civil claims, so usually in tort or wrongful act. They involve corporate defendants. There's usually a sort of, you could say, binary issue between a host state where the damage occurred and a home state, so where usually where the parent company is located, where the case is brought. And the primary goal of these cases are compensation for the victim. So there can be secondary goals in terms of correcting behavior or setting standards, but usually the primary goal is compensation. And it also, I think, distinguishes them from criminal cases that are much more about punishment, or even consumer cases that are much more about adjusting behavior. So it's really about the right to remedy, which is also why I put poor Milton here, because basically the question that these cases ask is, hey, we thought there were supposed to be remedies when there's wrongdoing, and there usually aren't remedies where the damage occurred. So can we get remedies abroad? So 4 factors, and I sort of emphasize, I think, the first 2 mostly. I put the last one a bit in italics, because that's I think what Tom's already discussed, again, more extensively and better than I could ever do from my abstract ivory tower academic perspective. So for the first, jurisdiction, the question of whether a court is competent to actually discuss the case. And before I dive into that, I think I think Antoine said something along the lines of that this case has been discussed in the Netherlands, and that we can sort of move this discussion to an international audience. And I don't agree with that, actually. I think this case has not really been discussed, isn't really part of a discussion in the Netherlands at all. A bit in the newspapers, a bit, of course, within the NGO community, but not so much. There's not a lot of Dutch publications on it. There's not a lot of political debate on it. And I think that also reflects on whether or not this will be a trigger for instance, the new National Action Plan, which I've sort of been involved with a bit. So we can discuss it later in questions. But I'm quite pessimistic on that, actually. I don't think the discussion is very. I don't think there's much of discussion anyway. But so jurisdiction, I think Tom also already mentioned the basis for the jurisdiction question in the Kiobel case itself. So first you have the Brussels I regulation, which gives mandatory jurisdiction to the court of the place where the defendant is domiciled. Now, in this case, you really still have to separate the different entities that you're litigating against. So the Dutch incorporated parts of Shell, so RDS, for instance, and the parts of shell that are domiciled abroad, so SPDC. In the first case, you have that mandatory jurisdiction based on the Brussels regulation. In the second case, you have jurisdiction based on the connected claims argument, so multiple defendants, same facts, principally same legal questions. And we can see indeed that this sort of construction, this sort of dual jurisdictional basis, has been used in a lot of cases that have been litigated in Europe. So you already mentioned the other shell case, and interestingly enough, that we will, I think, 4 shell cases throughout this entire presentation, but the shell case in the Netherlands, but the same principles also been applied in English cases. So the Lungoa case, the Okabe versus Shell case, a case against Unilever, and even there's now an ongoing case in Italy against Eni and its foreign, and I think it's also a Nigerian subsidiary that really uses the same sort of Brussels local law connection. Now, there are some differences, especially between how the Dutch courts have used this doctrine, how English courts have used this doctrine. And I don't have the time to go into that in much detail here, but as I see it, the English courts go much more into the substance of the case and the substance of the claim, and also into the relation between the different defendants, especially within the corporate group, and have been much more critical about applying this construction than Dutch courts have. So Dutch courts apply much more marginal tests where it's the company that has to show that the claimants are abusing this doctrine of connected claims, which is quite a high bar to meet. So these cases have been generally successful in the Netherlands, this argument. So it's been successful in the Kiobel case, but also in the Akbal and Milieudefensie case, but not always in the English cases. And what I find, and also what in the English cases happened quite a bit, is that the defendants have argued that the primary claim, so the claim against the parent company, is basically without merit. It's a frivolous claim only used to anchor jurisdiction over the foreign defendant, so over the foreign subsidiary. And there's now a case before the UK Supreme Court, which really goes into the question of what is the burden of proof, and also what are the standards that you have to apply to see whether or not that anchor claim against the parent company, so in this case also the Royal Dutch Shell, that it's actually a viable claim, that you have a serious, substantial issue against that other defendant. That's the Okabe case. And if you're interested in this, that's the sort of, I think, a case that one should follow. Now, there are some alternatives, and what I find interesting about the Kiobel case, and I don't think Tom mentioned it, but I think in the summons originally, the claimants argued that if the court does not accept jurisdiction on the basis of this connected claims thing, they might also assert jurisdiction based on form of necessity or form necessitatis, which essentially says, well, if there's no other court available to you and you face denial of justice, you could bring the claim in the Netherlands, provided there's some sort of connection with the Netherlands as a forum. So, and that connection could, for instance, be the presence of Royal Dutch Shell, parent company, corporate policies that are made here and maybe applied to, and so on. And I think when we get to the questions, I really would like to hear from Tom, like how they saw that construction happening. But because it's one of the only cases where that argument has actually been brought, I was sort of interested in that as well. And what was also interesting is that not all European Union member states actually recognize form of necessity. Some do, some don't. And there's now a proposal, I think came out just a week ago in the European Parliament, to amend the Brussels regulation and introduce a form of necessity provision that will be applicable throughout the European Union in these kinds of business human rights claims. So the second thing that's really relevant to these cases is the question of applicable law. Now, again, in the Kiobel case, I think it's been mostly discussed how that's here Nigerian law, but in general, this issue of applicable law is regulated by the Rome II regulation. And the main difference between the Rome II and the Brussels I regulation is that Rome II has a universal scope. So Brussels I only applies to cases against EU domiciled defendants. The Rome II regulation applies in all over all cases and claims, or at least all civil cases and claims. And the primary rule in this case is you use the law of the place where the damage occurred. with keeping in mind that it's the defendant who has to adjust their behavior, and if they act in a certain place, they have to abide by local law. So if they violate those laws, those are the laws that you should use in the civil case to determine liability. Now, we've also already discussed a bit the problem of that also comes with local statutes of limitations. And now, as I understand, in Kiobel that hasn't been much of a problem, but in other cases in the EU that has been a problem. So there's been a case from Sweden, the Arca victims case concerning pollution occurring in Chile in the 1980s. Yeah, I see, Antoine. Where they initially applied local law and determined that, yeah, indeed, statute of limitations was a year, and they couldn't file the claim anymore because that had passed. And only on appeal did they apply Swedish law. This was a case that actually concerned facts that occurred before the Rome II regulation was enacted. But now in another case concerning factory fires in Pakistan, the case was filed in Germany, the DBR case, they did apply Pakistani law under the Rome II regulation, and again determined that the statute of limitations was 2 years, and they couldn't bring the case in Germany anymore. And here you see that this kind of procedural wrangling, it doesn't just hurt evidentiary questions, witness statements, and so on. I think some of the things that Tara said, but it also can affect whether or not the claim can actually be brought. And you have to remember that before victims actually realize, wait a minute, I can actually bring this case in a European forum, before they actually have access to a lawyer, before they have access to funding, we're usually years and years and years after the damage actually occurred. So if the statute of limitation is short and you have to use that local statute of limitations, you're in big trouble when you get to European courts. Now, there are exceptions. If it concerns environmental damage, the law of the place where the decision was taken could hypothetically be used. You could even argue that the law of the forum, if it concerns an overriding public interest, that is the law that should be used, but I haven't seen that actually been argued in cases thus far. So that's sort of an unexplored avenue, so to speak. And I'll skip over some of the rest of the issues here. One thing I'd like to highlight before I finish, and yeah, Antoine, I'm looking, I'm very aware, is that, like Tom said, this is one of the few cases where human rights, which usually very much factor into the background of the European cases. So in the American cases, the Alien Tort Statute, human rights is at the forefront. It's really about applying international standards. In the European cases, usually it's transformed into a more domestic tort law issue. So you use either substantive law from abroad, or you use, if it's a common law question, unwritten duties of care, but that still you frame it in sort of domestic tort law issues. Now that also creates all kinds of problems, because not those laws are usually not really amenable to transnational, very complex transnational questions of parental duties of care, of guidance within a complex structure like a transnational company. But it also makes you sort of lose sight of the international dimension, and also I think, and that's what Tara also highlighted, you tend to lose sight of what fundamental interests are at stake. This is not the same thing as being hit by a car on the road and suing for damages. This is really about the fundamental, long-term, and often destructive influence of a corporate actor that's for all intents and purposes outside of the law. So this case is interesting because it is actually the first case to directly apply human rights terms horizontally to a foreign direct liability case. And all the other cases, still it's really about domestic tort law. So there's a lot of sort of questions that are still open in these cases, whether or not they're actually enforceable. The Kiobel case, when it went to the Supreme Court, the court was really sort of concerned about possible diplomatic fallout. Now, we haven't yet seen a successful case in Europe yet. We haven't seen a final decision in favor of the victims yet. So I'm really interested to see if actually a case like that will be decided, whether there's actually any diplomatic or international consequences whatsoever. Just to see whether the whole idea of we're going to get in so much international trouble is correct. And I think there's a stop here before I go overtime.
Yeah, also just because Tara needs to leave and wanted to add something to the discussion still. So Tara, the floor is yours, and then we take the questions for the two remaining speakers.
Yes, and I'm glad that there are no questions for me because I'm going to hop off. But I just wanted to point out two things that came up in Tom and Lucas's presentations that are really relevant to the Dutch audience and to the Dutch National Action Plan. We talked a little bit about discovery. And when you saw Tom identify 4 different subsidiaries or 4 different members of the group, Tom can correct me when I leave, but my understanding is that's a direct response to one of the earlier cases in the Netherlands involving Friends of the Earth, where Shell tried to defeat the claim on jurisdiction, saying that they were suing the wrong parent company. Royal Dutch Shell is a new invention. It's the merging of 2 subsidiaries. But Shell didn't need to tell the claimants who they are supposed to sue, right? So there's one company in the UK, one company in the Netherlands, and Shell just says, you're suing the wrong company, figure out who the right company is. Now, I was doing research on the Shell case at the time. 4 lawyers involved in doing research to try to sort out who was responsible, which of these 2 subsidiaries should be held. We could not figure it out. We could go from Shell in the Netherlands and the UK down. We could go from Shell in Nigeria up. And then there was a massive gap in the middle. And it was that gap that would have told us who the parent company is. And that's significant. That's a really significant problem. And it goes to Dutch discovery rules. And so when I talk about reforming the Dutch discovery rules, that's part of this. The case ended up being fine for the claimants, but at the same time, that's a really problematic use. And as we're talking about misuse of the rules, Lucas raised the DBR case in Germany. And there we saw significant manipulation by the company over the use of statute of limitations. KIK waived the statute of limitations so that they could continue to negotiate a settlement. When it went to the German courts, it was the KIK expert who raised the issue of a statute of limitations. And they brought it to the German court and said, actually, this is time barred and we can't take the case forward. You don't have jurisdiction over it. Those are some significant problems and manipulations by companies using the rules, the procedural rules within European states. And my hope is that when we talk about national action plans and reforming these rules, that we take a holistic view of them, that the Netherlands really delves deep into its rules of discovery, its procedural rules, and figures out what it would be like if a company tried to use some manipulative tactics, what it would be like if it was somebody like Esther Kiobel trying to use these rules from Nigeria, and really frame their national action plan with that in mind. So that's all I wanted to say. Thank you so much, Antoine, for having me, and to everyone else, and to Tom and Lucas for amazing presentations. And I'll see you guys soon.
Sorry that
Bye.
attend the Q&A, but thanks a lot. So let's turn maybe to, we have, I think, a few questions that were raised by some of the participants. Mercedes, you are tasked with the responsibility of asking those questions, of monitoring those questions, so up to you.
Yeah, thank you. Thank you for these presentations. We have quite a few questions that came in. The first is directed to Tom. From Ekaterina Aristova. She asked 2 questions, and they link to the relationship between torts and human rights. To what extent did the Dutch courts engage with the human rights framework and arguments in the course of tort litigation against multinationals, and rely on or refer to the international human rights standards such as the UNGPs or comparative jurisprudence in this field? And then there's a follow-up question. What type of remedy are claimants seeking? Compensation or something else? And then there's a question.
Let's do actually directly the response.
Directly that one. Okay.
And the next question. So Tom, to you.
You want me to answer the question now?
Yes, please.
All right. I think the first question is actually maybe better suited for Lucas. It's more comparative. Like in this case, it wasn't really, we didn't invoke tort law. So it was mainly human rights, which was directly invoked. I think I can also go into the last question now from Anna Beckers. It was actually the reason we did this is that this is the way it is done in Nigeria. So in Nigeria, it's possible to directly invoke. Oh, sorry, I will repeat the question for the people who are for the audience. So the question is why we invoked human rights and not tort law, and whether this was because of the claim being time barred under tort law, or whether were other strategic reasons why tort would be less favorable to rely on. And my answer on that is that this is the way these kind of cases, human rights cases, are litigated in Nigeria. So based directly on Nigerian human rights law. And it would also be a little bit strange to fit a human rights violation into a tort, because these are sometimes not really suitable for the let's say the substantive the substance of these human rights violations. So that was mainly the reason we did this. And with respect to the remedy, we claimed that will be compensation. So far we claim a determination of liability, but once we have established that, we can go on to seek compensation for the claimants.
Okay, thank you, Tom. Maybe Lucas, you want to weigh in on the first question?
Yeah, whether or not the international human rights standards are relevant for these cases. Well, thus far, I've identified 3 Dutch cases that you could broadly frame within the business human rights UNGP's angle, and none of them have really featured the UNGPs or any human rights outside of what Tom just mentioned on the invocation of human rights horizontally. And I think there's 2 main reasons for that. The first one is that I don't think a lot of courts, and in general, I think legal professionals are very well versed in business human rights language. They're not really trained to look at that in as a concept, as a field of law, the way I think some of us, at least participating in this meeting, are, like, have this as a sort of separate problem of international law, and have it and also have the terminology ready, basically. That's one thing, and I'm not so sure because sorry, I won't go into this detour, maybe later, but that's one reason. I don't think the courts are very well versed in that. The second reason is, and that's I think more important, is that it also depends on what the parties invoke. If you phrase your case essentially as a wrongful act or tort case, and the defendants argue based on just domestic law, domestic wrongful act law, domestic doctrines of law, and that's what the courts will engage with. I mean, it's a civil case, so courts are supposed to be passive in that respect. The only thing I've seen is that in the original, the district court in the Milieudefense and Akban case, they did show that they were aware that this type of litigation is going on. So there was this claim, and this is sort of a bit of a nitty-gritty thing with the jurisdiction question. But one of the points that Shell tried to make was that it was unforeseeable for SPDC, so the subsidiary, that they would be sued with their parent company. And they invoked a European case in that context. And the court said, well, that's bullshit, basically. And they mentioned a lot of cases, including, by the way, the original Kiobel case, the 2013 Kiobel case, saying, well, you have been sued multiple times together with your parent company. Your parent company has been sued separately. So there's no way you can claim that it is completely unforeseeable that a thing like this will happen. You'll be sued in the courts of your parent company's home state. So at least some judges, I think, are aware that these cases are going on, but the extent to which they're familiar with the UNGPs. I mean, I just finished the national baseline assessment, and I was sort of surprised how little even dedicated professionals, people who were supposed to be working professionally with the UNGPs, either in government or in companies, are actually very aware of the UNGPs themselves. So I think those are 2 factors that answer your question.
Turning to more questions directed towards Lucas from Anonymous, there's a critical question regarding the question of sovereignty. In foreign direct liability cases, European courts basically decide on cases concerning foreign nationals, technically foreign companies, and atrocities that happened abroad. It seems European courts do so because they do not feel comfortable to leave the victims without remedy. Does this trend infringe on state sovereignty? In this case, Nigeria's sovereignty to decide its own cases? If so, do you see the need for an international civil liability court?
Those are 3 questions at the same time. I hope I'll tackle all the aspects. Okay, sovereignty in general. Does this infringe on state sovereignty? That depends really on what you define as state sovereignty. So let me first answer this very technically, and that's that a court applying foreign law against foreign defendants in a civil context is nothing new. That happens all the time in commercial disputes. It happens in trademark infringement. And whether or not it's based on choice of court agreements or on other or exclusive jurisdiction clauses, or whether because it's on the basis of tort litigation, it happens all the time. So this is, in that sense, in a very sort of superficial sense, not that exceptional. Now, of course, especially in the case of Kiobel, because you have the state so deeply involved in the in the harmful acts themselves, and even in the other cases, the Milieudefensie case and most of the cases I mentioned, it's not just about corporate wrongdoing. It's about the inability of a state to either write appropriate laws that reflect human rights obligations, or the inability to enforce those laws or have functional legal systems where you can bring those claims. So, of course, there's a regulatory angle, and in that respect, you could say a sovereignty, a self-determination angle there. But then the question is, what do you define as sovereignty? Do we only talk about state sovereignty in a very sort of formal way that the state, only the legal construct, the state, holds the sovereignty? Or do we also talk about what sovereignty entails? Like what? Because I would argue that sovereignty also entails certain obligations, and it entails obligations to actually enforce human rights standards, to ensure the well-being of your population. And at the end of the day, it's that population, so the claimants in this case, that are driving these cases. And I think it's very strange to say, well, on the one hand, we are okay with a company like Shell, who, like Tara said, was granted the concession over all those oil wells by a colonial government, and is now sort of, and even the Nigerian legal system was imposed by the English colonial government, and say, well, no, that's actually just part of normal state sovereignty. But then the question of local communities to a court to say, hey, would you please enforce those laws? It's not just about writing new norms. They're not saying, well, Dutch courts, please write a new rule that punishes Shell. No. They're just saying, please enforce the laws that our legislature has written and is apparently incapable of enforcing. And I would say, well, that's actually a reinforcement of local sovereignty rather than a detraction from that. So that's two. And then the third one, do you see a reason for an international civil court? No, not at all. I don't think it's feasible in practice. I don't think it's desirable. I think that would take away the issues like this from that would detract, I think, even more from local sovereignty, because here you still have an interaction between Nigeria and the Netherlands. You have Nigerian professionals who are engaged with the case, not just this case, but also the Akpan case, who give evidence, who help the court understand Nigerian law. And if you take it away to an international court, and again, even disregarding all the feasibility questions and money and organization, what have you, even if you could solve all those problems, you would end up with like a weird bubble that's only about really corporate responsibility, and not about community engagement, not about international engagement between states and legal professionals and so on. So no, I don't think that would solve the problem. It will make it worse. Sorry, that was a very long answer, but I love this question.
Yeah, yeah. There's another question directed to you regarding private international law. It says, with regards to orthodox private international law, do we need to adapt international private law to suit the needs of a globalized economy? Do we need to wave goodbye to doctrines such as neutrality? And how can we do this without cherry picking the law that we think suits the interests of the victims the most?
I'm trying to find a way to answer this question without going into another 10-minute rant. So the first thing I'd say is for the person who asked the question, please send me an email, because I discussed this at length in my PhD research, because the issue of neutrality for private international law, I find very interesting, and I've talked about this, but it took me, I think, an entire chapter to answer that specific question. So please send me an email at l.roorda@uu.nl, and I will send you the thesis, and that answers your question in general. But let me do it very shortly for the other participants. I think there's already been a lot of effort by, I think, more specialized private international lawyers to question whether PIL is actually as neutral as it says it is, because you're pretty much always in a globalized economy engaging with questions of power and engaging with questions of distribution of power, engaging with policy questions. So that already sort of detracts from your neutrality. But again, without going into a long answer, not necessarily. I don't think we need to change the rules of private international law as much as more effectively apply those principles that are already there. And I mentioned a couple in the presentation, and how we can sort of use the Rome II regulation, maybe just slightly, to be more receptive to these kinds of cases without being only the victim's law, because I completely understand why that would be undesirable as well. But I think there's a lot of aspects of private international law that are still sort of underexplored in cases like this. And I mentioned the Rome II regulation as an example, and the overriding public interest rule. It's already in there. So let's just first see how far we get by using it before we start sort of revamping the system.
Okay, thank you. We have one final question for you, Tom, but I know that you're leaving in 5 minutes, or not even. Maybe you can just, I don't know if you saw it. There is a kind of lessons learned from other cases for this case on Shell. So how did you build at Praken on your expertise on human rights litigation for this case?
Yes, I think like the Milieudefensie case that we have spoken about many times today already, was really a trial or an error case, so to say, that started in 2008. And I think it was one of the first cases ever brought on this basis. So this case is currently, like last week, the final hearings were taking place, 2 days of hearings on appeal. And so this case is running already for 12 years. So there were a lot of lessons learned in that case that we have used for the Kiobel case, I think. Yes, that's for sure.
Thanks, Tom. Maybe one final question from my side. When do you expect the final decision?
In Kiobel?
Yeah.
That depends on whether the court has more questions for the parties, which it sort of hinted to during the last hearing. But if there are no more questions, we think the final judgment will be delivered next year.
Okay.
Yeah. And maybe one last point in response to Lucas. You mentioned the forum necessitatis, and we indeed invoked it. We actually said that you couldn't expect from these plaintiffs to bring the case in Nigeria because it was still dangerous. it is still dangerous to do it because the judicial system is not independent enough. And we refer to the fact that the presiding judge of the Civil Disturbances Tribunal was actually promoted to being chief judiciary of the federal court in Nigeria. So this is, yeah, you would say like he's one of the main accomplices in this case, and he's still there. So we actually refer to these kind of circumstances to substantiate that basis.
Okay, I see that we still have questions, but unfortunately we really have to close down. Tom is leaving, but also our staff needs to leave at one point. So I want to thank you all for participating. I want to thank obviously Tom, Lucas, and Tara for their insights. And yes, I look forward to hopefully hosting you again in future events. Bye-bye to all.
Thanks for the invitation.
Welcome.
Bye.